The results of the audit reveal alleged robo-signed documents, alleged illegal notarizations, and alleged fraudulent foreclosures. MERS processing companies have done so to transfer mortgage loans at high speeds while avoiding county recording systems and Texas state law. They have already hired people to forge signatures in an assembly line fashion, disregarding our state laws and regulations concerning the execution of these documents and the conduct of notaries. Each county clerk in Texas, and indeed the whole country, maintains records of who owns lands within that county. Texas state law requires the recording of documents regarding liens on property, which includes the deeds of trust and the assignments relating to the transfers of those loans. This is vital to the public. This proves indispensable to facilitating mortgage financing, but all forms of commerce. The office of the county clerk in Texas began in 1836 while superseding the escribano under the Spanish-Mexican rule. So real property records track and perpetuate the American dream of family ownership of property. The rush to securitize these mortgages over the last several decades under the guise of mortgage-backed securities has led to sloppy practices in the processing of the legal paperwork at whatever cost. The securitization process is completed by financial institutions who collect mortgages into trust, sell certificates in those trusts to investors, and investors in turn receive income from the mortgage payments. This process can result in several transfers of mortgages and notes over a very short period of time, including a transfer from the loan originator to the securitization seller, from the securitization seller to the securitization depositor, and from the securitization depositor to the securitization trustee. These lenders and mortgage servicers have violated not only state law, but people's property rights by recording alleged forged and fraudulent documents, which now cloud the titles of millions of unsuspecting American homes. This process end may result and affect the property owner's ability to refinance, to sell their property, and to obtain title insurance. Reasonable lenders and title insurers rely on the integrity and the accuracy of the land records that are recorded. Now becomes an issue for thousands of titles in the land records in my office that I have a duty to preserve and protect and maintain. The integrity of the land records must be protected from destruction. These lenders and mortgage servicers must be held responsible and held to restore the integrity of the public recording system. Tangible economic and social harms resulting from the alleged misconduct of MERS and these lenders include the uncertainty of title, inability to discover and remedy title defects of countless homes due to illegal foreclosures, which result in decrease in real estate values, tax collection, decrease in employment, social stability, and the quality of life. I'll let Dave Krager, who currently serves as paralegal and legal research analyst for Wade Cricken, an attorney in Dallas, who specializes in consumer and real estate law and foreclosure defense, to tell you more. Your manuals and the book he wrote are there for you to review. Dave?
Thank you. Thank you, Nancy. Good morning, Commissioners.
State your name, please, Dave.
My name is David Krieger, and I'm here this morning to present our audit results and a little commentary for the Commission to consider. We began, and I want to kind of reflect back on something that Ms. Reister said. She was talking about the clerk school that I lectured at. The subject was MERS 101. This was done a year ago, January. And I was invited to lecture there because of a meeting that I had with about a dozen of the county clerks from around the country, or in the state of Texas, rather. And the concern was, you know, basically the same. They were worried about the condition of the land records. Not surprisingly, other county recorders, registers of deeds, and clerks have done the same thing. The first one that was done was by John O'Brien, who is a very vocal friend of mine, who is the Register of Deeds for Essex County, Massachusetts. and he has filed a paper that we have included in the back of your book asking for restitution from DocX. DocX is a document manufacturing plant whose president is now going to prison. And the reason that she's going to prison is because that she admitted to the types of activities that Ms. Reister was addressing here earlier. We need to have our elected officials also understand that they too are involved in this as much as the Williamson County homeowners. And so we pulled the files on every elected official in Williamson County and we audited them. If you have MERS on your deed of trust or anywhere in your chain of title, it is listed in this report you see before you, beginning at page 89. Fortunately, Commissioner Covey, you don't have to worry, you're not in there, and neither are you, Judge Gass. But the rest of you are all affected by this. And it's, some of you have more than one property. Unfortunately, we did not do a full-blown chain of title assessment. We just basically did cursory reviews because of the time frame. But we pretty much put this into perspective as far as what we're seeing. Part of the problem with the MERS system is that when they started out, the intention was to streamline the sale and transfer of mortgages on Wall Street. That's a given. The unfortunate thing is that now that we are looking to our elected leaders to enforce some of the misbehaving that's been going on in the industry, because of the fact that we have an attorney general in the white, in the cabinet, executive cabinet, named Eric Holder. And not many people know that Eric Holder was a partner in the DC law firm of Covington and Burling, who represents MERS Corp., which is MERS's parent. The official MERS and MERS Corp., as we know now, began January 1st of 1999. And when this happened, they had signing agreements in place from 1995 forward, and some of the people whose signing agreements may have been expired are still executing documents, even though the former corporations are defunct, and they're using 1995 MERS seals on documents, that's what we call a marker. Markers are used basically in this audit to identify what we consider suspect behavior, which could be considered borderline criminal, if not criminal. Much of what we saw, which I'll go into some detail here when we discuss the audit results, and I don't want to take up a lot of your time, but the circumstances are such that we're looking at robo-signing, and probably over 50% of the land records in Williamson County are affected. Over 50%. And Ms. Reister earlier had quoted that they feel that the county lost over $1 million. My figure is exponentially larger than that. When you look at securitization and you look at paragraph 19 or 20 of the average deed of trust, depending on what form you're looking at, it says in there that the lender can sell the note or the partial interest thereof. That means that he could split it up into 35 pieces and put it into 35 different securitized trusts and launch them out all over Wall Street and wrap them in derivatives and sell them ad infinitum ad nauseum. You would have absolutely no idea, because of the MERS database, who actually owns your loan. Normally when MERS gets involved, it lends, because of no regulatory oversight, there's room for abuse, and that abuse has run rampant all over the United States. It's not just confined to Williamson County. It's everywhere. But I'm anticipating, based on the information that we have surmised from the audit that we conducted, which the results are there, out of the 1,576 documents, it pretty much is a good cross-section that over any time that MERS is involved, if we were to pull the entire scenario of MERS-related documents, the notes were probably sold before they were even recorded. I want to introduce David Rogers, who is the attorney that rendered the opinion letter for this audit, and I want to let him address your other questions.
Okay, thank you.
Commissioners, Judge, may it please the Commissioners Court.
David, please state your name.
My name is David Rogers. I'm an attorney. I live in Pflugerville, and I practice in Austin, Williamson County, and in Hayes County primarily, occasionally in Burnett County. What I do is homeowner defense. So I'm neck deep in these legal issues. To answer your question succinctly, Commissioner Berkman, the answer is find a lawyer and talk to them about the problem. MERS, according to their own press releases, their own website, is involved in more than 70 million mortgages in the United States. If you have taken out a mortgage in the last 10 years, the odds are very high that MERS is involved. This is seems like it must be a simple area of the law, but and that's what I thought when I first started doing it, but it turns out to be quite complex. The opinion letter that I have attached here, and I'd ask you to turn to page 145 in your audit book. I'm sorry, 143, talks about what MERS is, because I think that is a central question. MERS is a problem. Well, what kind of problem is MERS? There are a number of courts that have looked at what MERS is, in addition to the court opinions that I have excerpted there from the Washington State Supreme Court, from a New York State Appellate Court, from the Kansas Supreme Court, from a Missouri Court of Appeals, from the Nebraska Court of Appeals. I also have at the end of that section, beginning on page 50, something called the building blocks of MERS, and that is taken from MERS' own documents about what they say they are. Because Williamson County is such a hotbed of high technology, with Dell being centered here, I thought maybe a technology analogy might be a helpful place to start with this. Does anybody here know what a beta test is? A couple of yeses. MERS is something that should have been beta tested, that was released to the general public before all the wrinkles were ironed out. The laws of every state are different with regard to recording, what has to be recorded, what doesn't have to be recorded. MERS is designed as a centralized national database. It does not take account of all of the differences in the laws of all of the 50 states. We heard some discussion of Local Government Code 192.07 earlier. Clerk Reister talked about that, and I've got that excerpted on page 147 in the footnote at the bottom. To release, transfer, assign, or take another action relating to an instrument that is filed, registered, or recorded in the office of the county clerk, a person must, not may, must file, register, or record another instrument relating to the action in the same manner as the original instrument was required to be filed, registered, or recorded. What that means is the MERS business model is illegal in Texas. This requirement is that every time there is an assignment of the deed of trust, which is what MERS does, right? They transfer the ownership of your notes and your deed of trust left, right, and center, but they don't record it in the county deed records. Local Government Code 192.07 requires them to make that recording, and they don't do it.